Well, off to a story that has been high in demand. The Cannabis for Private Purpose Bill is set to be finalised by President Cyril Ramaphosa soon. It was approved by the National Assembly last November and passed by the National Council of Provinces just last week with 40 votes in favour of the bill and 3 against. The bill provides a new legal framework for the stipulated quantity of cannabis and the use of it in private settings. So what exactly does this entail? Let's have this discussion and further with Senior Associate at Adams & Adams, Ramon Pereira, who's joining us now via Zoom. Ramon, good morning. Thank you so much for making time for us. So what does this bill mean for individuals who consume and use cannabis?
Thank you, Alden, for having me. Basically, what it does is it tries to set out different types of offences. So it sets out about 4 tiers of offences, varying from the different kinds of offences you can cause. And then it also separates out what you're able to cultivate, what you're able to possess, and then it specifically specifies what sort of your smoking and consumption offences are. What this bill doesn't allow, it doesn't allow you to smoke or consume cannabis at all in a public place. And a public place is basically defined as a place where there's no private access. So you can think of obviously generally like your home or anywhere like that, but it goes further. So any kind of structure itself as well, which can be a private place. It's not limited to a home per se. And what it also does, it also outlines sort of things that even if you are in a private place, certain outline where you can't smoke in you can smoke in a private place, but you can't smoke in a private place in the immediate presence of a non-consenting adult. It also outlines various things that are relating to children in particular, where it has various protections for them, where obviously children aren't allowed to possess or cultivate themselves, which then would live up to various types of fines and imprisonment as well. And then, yeah, it just basically, as you mentioned, gives sort of the quantities within that as well.
Yeah. What's the definition of a private place? Can let's say, for instance, a small boutique say that they are a private place that allows for smoking and therefore the smoking is lawful in that particular space, even though it is, for instance, in a setup that is a mall where there is access by the public?
Yeah, so I think that will be something that's going to be challenged probably in court when this becomes an act. Because, yeah, as you'll know, there's various boutiques all over and there's different kind of grow clubs as well, which I think are going to look to this particular act to see whether they're compliant, and they're going to obviously argue that they are compliant. The bill itself, which is going to become an act, doesn't necessarily exclude those. It basically just says pretty much any kind of structure which would be which is not open to the public access. And then the definition is, well, then would have to be decided is what exactly is public access. Are you saying that we have to, in order to enter this particular club, I have to be a member of this club? Is that sufficiently limiting in terms of public access? So does that fall into the definition of a private place? But yeah, the bill itself doesn't necessarily exclude it, but it doesn't necessarily, it's something that'll have to be argued, I imagine.
Yeah. And then back again to the question around the quantity that you are found with. What exactly is that quantity? But also, it speaks about the public places. And I wonder, if you were to get onto a plane, for instance, and you have the limited quantity that is specified in this act or in this bill, it's still a bill, still waiting for the president to sign it, and it becomes an act. Mm-hmm. So if you have that quantity that is prescribed in the bill, would you be guilty of an offence if you were to get on a plane with it?
So I'd say arguably a plane would be considered a public space. Again, maybe this definition would have to be argued in court itself. But in terms of the bill, you're allowed to hold a certain amount in public. Obviously, it's still going to be concealed from the public, though, so that's important to note as well. It's not something you can just have around you. It needs to be concealed from public view. But you would be entitled to possess up to 500 grams of cannabis, fresh cannabis, 100 grams of dried cannabis, or 25 grams of solid or liquid cannabis concentrate. So that would be in a public place. Mm-hmm. In a private place, you're allowed to possess more than that. And I think those amounts are, I mean, I can get into it, but basically 3 kilograms of fresh cannabis, 600 grams of dried cannabis, and then about 150 grams of solid or liquid cannabis. But that's in a private place. Whether you would consider a plane, I imagine a plane would be considered a public place, and I think as a default you should consider it that. Which then, in terms of the bill, by definition, you could possess at least 100 grams of dried cannabis on your person, I imagine.
Okay. Then on the Guardian is guilty of an offence if they allow a child to smoke or consume. Does this
Yes.
mean that that the child doesn't have any criminal capacity? So you can't find the child guilty of being in possession of the cannabis. And what's the definition of a child?
Yeah, so that I think you would then also have to look towards so you'd have to look towards in terms of criminal liability of what a child can actually do and what criminally they're entitled to do. But there is, or what they would be liable for in terms of criminal charges. But there is specific protections against the child, against the guardian itself, who may have actively allowed a child to deal in cannabis, for example, which can then attract up to 15 years of imprisonment for a guardian if they actively engage with a child to be involved in that. The definition of an actual child is just the minor, which then basically the minor age at the moment is 18 years of age. 18 years of age.
Well, knowing that cannabis is also used for medicinal purposes, but then you also have the Rastafarian community as well, do you foresee a challenge specifically when it comes to the use of cannabis for children?
Yes, definitely in terms of, well, I mean, yeah, I wouldn't really know the answer to that, but I would imagine from the Act, if they are under the age of 18 and a legal guardian is involved within that, then yes, it seems that the guardian would be liable, definitely of an offence, if they were to have a child which was under 18 involved in it, yeah, basically smoking or consuming cannabis, yes.
Yeah, and strangely though, the Act allows for the children to assist with the cultivation, well, of course, in the presence of an adult.
Yeah, so that I find interesting as well in the bill. So cultivation, you're entitled to cultivate up to 4 flowering plants yourself in your private place. But you need to restrict access to children in that space as well. So you need to take reasonable measures to make sure that children don't have access to those plants at any one time. But they are entitled to be involved in the cultivation process as well, but it needs to be in the presence of the guardian and has to be under their supervision.
Yeah. Another interesting bit that I find in this bill, and the question that comes to mind, is around possession of cannabis in the workplace, considering that in some workplace spaces it is deemed as a drug and a prohibited substance within the workplace itself. What does this law then mean for somebody who is employed at a company that has a prohibition when it comes to the possession of cannabis?
I mean, that would be an interesting question as well, because I think your employers, obviously, they have their own standards and they're entitled to have their own standards. They're entitled to have their own limitations, at least. And but then at the same time, obviously, it's got to be in line with the law itself as well, though. So whether an employer, whether they would be found liable of an offence in terms of the Act, they would not be found necessarily an offence in terms of the Act, but whether they'd be in line with the employer's code of conduct, that would then be a separate question that the employer would need to answer. And whether someone would be able to challenge it in terms of the Act, yeah, I think that's an interesting question and interesting debate to have, actually.
Yeah, very interesting one. And then the expansion of criminal records for people who had been found guilty for possession of cannabis. When it comes to the criminal record, would the minister have to look at the quantity that the person had at the time when they were convicted?
Yeah, so the bill itself does an automatic expungement, which basically means that the South African Police Service is directed to, and there's various acts which someone could have been found liable for cannabis possession or use, and it's automatically expunged. It then does go into, that if someone does not necessarily qualify, then they would be able to then challenge that disqualification, and sets out quite rigorous grounds which they could then follow, and that the minister needs to provide reasons, etc. It doesn't really go into what exactly would the disqualification. Yeah. It could be that they would look to, so within the offences, there's what's called a trafficable quantity, what's called a commercial quantity. And obviously trafficable is a lesser quantity, commercial is obviously a higher quantity. So yes, maybe the minister, in deciding that this person would disqualify, would have to look at what are the guidelines that are set within trafficable and commercial, and they would maybe use that in terms of their reasoning. But how exactly they would go about that and what exactly the qualification or disqualification process is isn't really outlined in the bill.
Okay, Ramon, a final one is the bill does not necessarily legalize the sale and trade of cannabis. But if I, for instance, tell Naledi that here I have a bankie that I'm going to give to you, Naledi, and Naledi then decides to give me something else in return, something like butter, for instance, would that be considered to be a sale?
Yes, so the act itself goes into what would be considered consideration, and it outlines basically any kind of, if you were to exchange a bankie for anything, including something like butter or a favour or anything like that, that would be considered consideration. The bill does allow you to exchange it, but free of any consideration. So in other words, you expect nothing back in return. You're just freely giving that person away. You are entitled to do that, but then within the limits of the amount that other private person is entitled to possess or to cultivate, etc.
Thank you so much for your time. Ramon Pereira is a senior associate at Adams & Adams. And just to be clear, it is not law as yet. We're still waiting on the president to sign the bill into law. And once that bill has been assented by the president, only then does it become law. So be very careful around the possession of cannabis.